There is no job that is too beneath you to support your children. Because let me just tell you why I say that. My mom had us to feed, right? And she was about to take a job working on a garbage truck. And that was back in the day when people were not putting their garbage in plastic bags. It was just being a tin trash can, and you would have to hop off the truck, pick it up, and dump it. And you know why she was going to do that? Because she had children to support. Everybody always does that. I don't know why.
It's kind of awkward.
All right, court is calling 2023 CR 2677, State of Texas versus David Duenas. Could I have parties announced for the record for the state?
Second for the state, Your Honor.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, are you David Duenas? Do you have any objections to this attorney standing in for Mr. Martinez? You don't have to speak up. Nobody can hear you.
No, ma'am.
All right, you were found not guilty on count 1 and guilty on count 2. The jury asks that you be placed on community supervision. It's the court's understanding that the defense is waiving the PSI. Is that correct, defense?
That is correct, Your Honor.
Any objection from the state?
No objection, Your Honor.
All right, so I have a few questions for you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Duenas.
All right, I don't know why people always whisper when they come up here. I know that when people are out in the community, they're not whispering. So you're gonna have to put some bass in your voice.
I'm just scared to yell or say too much.
No, you need to speak up so the court reporter can hear. So what is your name?
David Duenas,
All right, are you employed?
not at the moment.
When's the last time you had employment?
Barely 2 months.
And what were you doing?
Car sales.
Okay. And how many children do you have?
5.
And what are their ages?
My oldest is 9, 7, 6, and then 5.
That's only 4 children.
Oh, I'm sorry. I forget my newborn. She's a year.
Okay. And if you're drug tested today, what would the results be?
Negative.
Have you ever used any type of substances in the past?
No, ma'am.
All right. Any other questions?
No, Your Honor.
No, Your Honor.
All right. So the jury is asking that his punishment be 2 years in the prison. I'm still waiting on the Duenas file. Where's the file?
Sorry, Judge. Can you finish that thought, Judge?
Hmm?
Can you finish that thought?
Yes, just 1 second. All right. So the jury assessed punishment at 2 years in the prison. So I consider I'm the person who's assigned conditions to you. So the first thing is, what length of probation time are you all asking for? Got it.
No, sorry.
What length of probation time are you all asking for?
Your Honor, the 2 years in probation is what we understood the jury to.
No, the jury is just saying that his prison sentence is 2 years, but I determined the length of probation time. So for the length of probation time, is there any requests from either side?
Your Honor, defense would request that it would be for the 2 years.
Your Honor, the state would request an upper limit of somewhere in the range of 8 years.
All right. All right, this is what the court is going to do. And count 2. Court is going to sentence you to 2 years in the prison, suspended and probated for 5 years. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And Ms. Abrams, can you let probation know I'm serious about the no employment with as a home health care provider with minors? The BIPP course. There's going to be 300 hours of community service restitution. Parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of deadly weapon. Field visits. One time per month for 3 months. There is to be no contact with Danessa Duenas, Christian Rodriguez, Charles Watterson. All right, is there any restitution to Christian Rodriguez?
No, Your Honor.
Okay. Probation. Is there anything else?
No.
All right, is there anything else you need from the court to be successful? Again, you're whispering.
Ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a jury trial, you do have a right to appeal. With regards to count one, you have a right to have that expunged. Is there anything else?
Your Honor, at this time, defense would request that you consider the minimum supervisory fee due to his numerous dependents. And also if Your Honor would address the removal of the GPS device.
All right. What is the court cost in this case? What is the court cost in this case?
Oh, sorry. Judge, what's the case number?
It is 2023 CR 2677. Yeah, I'm good. Thank you. I'm good.
You said the court costs?
Yes.
There is no court cost on it.
No. There's going to be a court cost as to count two. So for aggravated assault with a deadly weapon, what are the court costs?
She just got back.
All right, thank you.
Yeah, I'm sorry, Judge.
All right, the court costs are normally for this type of offense. I can't give you the specific amount, but I know it's usually assessed at about $800. Would you be able to pay that in installments?
Depends, like, soon. Like.
They will set you up in installment payments.
It just depends how soon they can do it, because I don't have the money right now.
Okay. All right, if there's an issue with court costs, just let the court know.
Okay, understood.
All right. Now, with regards to the GPS state,
Your Honor, we of course defer to the court with the no contact order. I believe that largely covers the bases. And then just before we finish up today, Your Honor, the state would also respectfully request the affirmative finding of family violence.
all right, with regards to the affirmative finding of family violence, that would have been against the complainant in count one, that case?
Well, Your Honor, also, I could have been
Sure.
misreading it, Your Honor, so forgive me if I.
No, if you
misunderstand.
have law that says something differently, I will consider it.
So just looking at the family code, Your Honor, I was under Title IV, Section 71.0021, A1B. In the definition of dating violence, it says because of the victim's or applicant's marriage to or dating relationship with an individual with whom the actor is or has been in a dating relationship with. So because Christian was in a relationship with Danessa, and Danessa and the defendant had a relationship, we believe that meets the statutory definition for a dating relationship, and as such, an affirmative finding of family violence would be warranted, Your Honor.
All right, I'm not going to have an affirmative finding of family violence.
Okay, thank you,
All right,
Judge.
thank you. But thank you for giving me that
I'm
section.
trying to be, I got my green tabs, Your Honor, just trying to be prepared.
Oh, no, I appreciate that. All right, now with regards to GPS, I'm gonna have the GPS on for till February. Let me see. We're gonna have GPS tracking only until February 26th. State that will give you time to contact the complainant. That will give you time to let defense counsel know what areas perhaps he should not be in.
Thank you, Judge.
Your Honor, if I may, the GPS device is precisely what has impeded him from gaining employment.
Oh, no, it's tracking.
No, they won't hire me. Like, our dealerships, they won't hire me because of the GPS.
Right, so sometimes we have to look at places for employment other than what we wanted.
I've tried, they say the same thing, the ankle monitor, like even.
Oh,
like,
no, because I've seen, let me just tell you, I understand what you're saying. So for example, if I have a criminal case and I work at a hospital, they may say, Stephanie, I know you've been working at this hospital for 20 years, but as long as you have that GPS on, you can't work at the hospital. But then I'm like, but I gotta eat. I have children. You know what I do? I go get a job somewhere else. And I've seen people with GPS working at the McDonald's. And you know how I know? Because I've gone to McDonald's and I've seen them with their GPS on. So there are plenty of jobs available for you with GPS. It may not be what you want, but when people bring children into this world, guess what? There is no job that is too beneath you to support your children. Because let me just tell you why I say that. My mom had us to feed, right? And she was about to take a job working on a garbage truck. And that was back in the day when people were not putting their garbage in plastic bags. It was just being a tin trash can, and you would have to hop off the truck, pick it up, and dump it. And you know why she was going to do that? Because she had children to support. So you have 5 children to support. And guess what? You may not be able to work at a car dealership because you have GPS on. Get a job elsewhere.
I mean, like the minimum to take care of them, like jobs that are gonna pay me enough to take care of
Well,
them.
you're working and your wife's working. Your fiance is working.
Because my child support gets taken
Mhm.
off, so that's what I'm saying, I won't be able to.
Well, here's the thing, you're on tracking, right? You can get 2 jobs. And you know how I know that can be done? Because when my mom did get a job, other than working on a garbage truck, she was on rotating shifts. And you know how many hours she had to work a day? 14. And you know what rotating shift is? They have you on the morning shift. She would be on the morning shift for 7 days. Then she would get 3 days off. Then after those 3 days were off, she'd get on the middle shift. The middle shift was 3 to 11. And then after she worked 7 days for that, she'd get 3 days off. Thank you. All right, thank you. Then she would get 3 days off for that. And then she had the graveyard shift. And guess what? She didn't say, this job is beneath me, because she had to support her children. So you got to support your children. And if that means getting 2 jobs, then you get 2 jobs. That's what you're going to have to do. You understand? And when you're in this court, I require that people to have employment. And you're being on GPS till February 26th. Guess what? It's for your protection as well. You understand?
Your Honor, I do want to bring it to the court's attention that there will be a lag in the GPS. He is on GPS with pretrial. That does not transfer over to probation. He'll need to get that one removed. And then we typically give a little time for them to get another install.
How much time are you giving him for another install?
Typically, it's 10 days, Your Honor.
Your Honor, the cost of the installation of another GPS monitor, I believe, is prohibitive for him.
All right, I'm ordering GPS. So if you go to the Bexar County Jail, that's the only way for him not to have costs associated with that. And then that's going to be a whole can of worms. He would have to go into custody. They'd have to put the GPS on at custody. Then he would be released. Those are his only other options.
So he would, practically speaking, what would he do? Go get this one removed at pretrial, and then what does he get? the
All right, so
probation
we're off the record.
Sorry.
I'm gonna let
In Judge Boyd's courtroom, Jose Gonzalez just admitted he basically did nothing on probation. No classes, no payments, disappeared for months, and only came back in handcuffs after a warrant arrest. He blames being homeless after his wife's new boyfriend kicked him out, but the judge isn't buying it. Instead of sending him straight to state jail for a year, she offers a harsh deal, locked in inpatient drug treatment, probation extended, 120 sober meetings, constant drug tests, and field visits. Did she give him the tough love he needs, or go too easy on someone who ignored every rule? Let me know in the comments, and don't forget to like, share, and subscribe for more real courtroom moments.
Once I do outline those timelines, the burden would shift to the state. And I believe, and I don't want to speak for the state, but I believe they have one witness to put on.
all right. Then if you'll outline your
Yes.
reasons.
Your Honor. Briefly, the timeline before the court, and it's all available to be verified on the Bexar County information system that's available to the court. This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was arrested on this charge. If you look at those dates that are outlined, there are two relevant dates, both of them multiple years at a time. From the offense date to the action that the state took in August of 2017, that's a 5-year delay.
Mhm.
From August of 17 until his arrest on this indictment is a 6-year and 2-month delay. And I'm not even including the 3 months between his arrest and today's date, which that's an additional 3 months. Your Honor, believe that the length of those delays taken together or even individually is so prejudicial that it affects our ability to put on a defense in this case in violation of the United States Constitution, confrontation clause and the Barker v. Wingo case, and as outlined in the motion, and also the Article 1, Section 10 of the Texas Constitution. I'm not sure what evidence the state has that can surmount those prejudicial delays, but that is the relevant timeline, Your Honor.
All right. All right, state.
Your Honor, I have one witness and I have arguments. You want to hear from the witness first?
Yes.
Okay, Your Honor, state calls Deputy Angela Alvarado. So,
All right, if you move
The Barker v. Wingo factors as the courts apply them in the state of Texas. We need to look at the length of delay. I think in this case that all the parties can reasonably agree that that is a tremendously long amount of time in this case, both between the alleged offense date and the indictment, and then between the indictment and when there was any activity on behalf of the state, whatever attempts those were in 2019, and then again between 2019 and the state's I just say weak attempts to find Mr. Hinojosa and 2023. Any of those taken individually are presumptively prejudicial, but taken together, it highlights the exact reason that these laws are on the books, Your Honor, and it prejudices Mr. Hinojosa's ability to put on a defense. I don't believe the state's efforts to show diligence in this case rise to the level of certainly it can't overcome the negligence that's apparent from the file. And for that reason, we ask for you to grant our motion to set aside the indictment.
All right. In your motion, it states that the case was dismissed July 28, 2017, and then re-indicted the same case on August 22nd, 2017. Why was it dismissed?
from my research into the JE system, it looks like it was originally supposed to be a theft. And the statute of limitations would have run on the theft by the date that it was the case was received from law enforcement by the DA's office. It was initially dismissed as a theft, but then indicted as a misapplication of fiduciary responsibility, which is within the statute there, Judge.
Okay, all right. State,
Yes, Your Honor. So, because the length of the delay was over a year, the Barker case says, the court has to consider the other factors. So just a little bit more clarity on the cause of the delay. The case was indicted on August 22nd of 2017. The prohibited conduct, in the indictment is from, June 1st, 2012 through June 6th, 2013. So it's a little bit, longer because of the prohibited conduct, a little bit, less of a delay rather. The defendant was a fugitive from 8/22/2017 through 10/21/2023.
wait, I'm sorry, 8/22.
I'm sorry, yes, ma'am. 2017 when the case was indicted through 10/21/2023. We believe that's when he turned himself in, once the case when he turned himself in, Judge. We heard testimony from Deputy Alvarado that BCSO tried to serve the warrant on January 23rd of 2019 and January 25th of 2019. I don't have a witness to support the previous service date that was in 2017, but I can represent to the court. The notes from the MOCA system indicate that BCSO did attempt to serve the warrant in August 21st of 2017. So there were 3 different attempts to serve the warrant, Judge. The motion for speedy trial was not filed until November 30th of 2023. And the position of the state is that the defendant had not avoided service of the warrant 3 times. He would have been able to assert his right earlier. The defendant has to show that there was prejudice, Your Honor. Since it's over 4 years, the Barker case says that the court can assume there's prejudice. The state's contention is that the cause of the delay was the defendant's avoidance of the warrant. So I think the type of delay that the defense is claiming here is that their defense is impaired by this delay. But if the cause of the delay was the defendant's avoidance of the service, I think you shouldn't reward that, Your Honor. And there's a case, Dragoo v. State, which is a CCA case from 2003. And the holding in that is that the defendant acquiesced in the delay by avoiding service to the subpoena judge. So that's the state's contention, Your Honor.
All
I
right,
see that you deny the motion.
all right. And defense, it's your motion, so I'll give you a final argument.
Well, just briefly, Your Honor, there's no evidence before the court that he avoided anything. There's no evidence before the court on reference to a 2017 attempt to serve a warrant according to notes. And I just, as an officer of the court, and I've spoken to Mr. Wilkins, he and I discussed that entry, and that entry into their MOCA system, as he described it, is problematic. So I'd ask the court not to consider that. And again, Your Honor, I think the characterization that he's avoided service is inaccurate.
All right. And then the dates where they're saying he's a fugitive. I know sometimes people say fugitive, but nobody knows that there's a
Correct.
pending case. So for the dates, August 22nd, 2017 through October 21st, 2018, state when you said he was a fugitive, is that just a matter of there's a case in existence? Either he knows about it or he doesn't know about it, thus he's a fugitive?
Yes, ma'am.
Can our parties re-announce for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
Sam Locke for Mr. Enosa.
And are you Mr. Inosa?
Yes, Your Honor.
All right, so to both parties, I heard both parties' arguments. I always try to internalize everything. And I understand that in this case, there are probably complainants that are owed restitution, right? But at the same time, I have to look at the defendant's rights, that complainant's rights to have their restitution or be made whole, or for somebody to try to make them whole. And Mr. Wilkins, I know that this case did not originate with you, but the court has a hard time getting past the fact that the offense occurred on June 1st, 2012. Here we are in 2024. He was detained on that offense on June 1st, 2012, according to the defense's motion. Then he was released. Then a grand jury number was assigned in May 26, 2017. Then the case was dismissed July 28, 2017. And I understand the reason for the dismissal was because potentially the statute of limitations had run on the specific offense. But then he was re-indicted on August 22nd, 2017. And then the warrant was issued. The officer testified that she went to what she believed to be his address, spoke to an uncle, not him, and the uncle said he doesn't live here. And it doesn't appear from any witnesses that there was more investigation into his residence. Then the officer said she went to the employment and they said he doesn't work here. And then there seems to be no further investigation into his employment, which it's my belief, because I've had investigators do this before, it's easy to find where somebody's employed at. There's an entire system for people to look on the computer to find out where somebody has been employed. There's an entire system to look to find out where somebody, where their residence is. And she's saying that the uncle, she left a message for the uncle to get in touch with him, but I don't have any evidence before me that the uncle actually got in touch with him. So for those reasons and many other reasons, I am going to grant the defense's motion. Is there anything else?
No, Your
What's your name for the record?
Deputy Angela Alvarado.
All right. So everyone, you all need to whisper. If you can't whisper, then you need to confer outside. All right, state.
Hi, Deputy. So did you attempt to make service of a warrant in this case?
Yes, sir. It
And-
looks like on the first attempt was January 23rd of 2019.
Okay, and then did you attempt to serve that warrant on another date as well?
2 days later, sir.
Okay, and so on January 23rd, 2019, where did you go to serve the warrant?
The address I have listed here on this is going to be 3215 Fort Parker.
Okay, and did you have any interaction with anybody there?
I noted that I spoke with the uncle.
And but were you able to serve the warrant on the defendant, Mr. Hinojosa, at the time?
No, I was advised that he didn't live at that location.
Okay, and so what happened a couple days later on January 25th, 2019?
I went to a secondary address on that date. His work address at 5451 Grissom.
Okay, and were you able to serve the warrant on that date?
No, sir. I was advised that he used to work there, but quit the year before.
Okay, and did you try to serve the warrant before 2019 in 2017?
No, sir, that would not be me.
Okay, that was a different deputy.
Right.
So you were unable to serve the warrant on Tristan Hinojosa, but you attempted to serve it on January 23rd, 2019 and January 25th of 2019.
Yes, sir.
Okay, I pass the witness, Your Honor.
All right, defense.
Your activity in this case is limited to those 2 days in 2019, correct?
Correct.
Okay, there's no indication, you've got notes in front of you that you're reviewing, correct?
Right.
And there's no indication in those notes about why you came up with the 3215 Fort Parker address, is there?
No, sir.
And there's no indication in those notes of what business is at 5451 Grissom, is there?
No, sir.
Do you know what business is there?
Not off the top of my head, sir.
And there's no indication in these notes of why you thought Mr. Tristan Hinojosa was connected to 3215 Fort Parker, correct?
Not based off my notes, no.
Okay. And there's no indication in your notes of why you thought Mr. Hinojosa was connected to 5451 Grissom, is there?
No, sir.
Did you take any other action in these 11 years and 4 months between the alleged offense date and his arrest in this case?
Just beside the two dates listed on the warrant itself.
And those 2 dates were almost 2 years after the indictment, correct? A year and a half? Your 2019 attempts?
Okay, I'm not sure when
I'm sorry, I didn't mean to interrupt you.
No, I'm not sure when the date of when he was arrested. Is that what your question was?
No, indicted.
Oh, indicted, I'm sorry.
Okay, you're not sure. the
No,
date.
no, sir.
Pass the witness.
No other questions, Your Honor.
In Judge Boyd's courtroom, a deputy admits she only tried twice to serve an arrest warrant for a case that's been sitting for more than 11 years. No follow-up, no clear address, no real trail on where he lived or worked. Now the defense is fighting back, arguing the state waited so long that the whole charge should be thrown out. Should a case this old still go to trial, or did the system fail by dragging its feet? Comment your take below, and don't forget to like, share, and subscribe for more real courtroom moments.
Family violence as well.
Yes, I believe we're just gonna handle
Okay.
it, Judge.
All right, court is calling 2023 CR 1478 and 2023 CR 5264, State of Texas versus Kevin Michael Neuenfeld. Could I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
Lindsay Shaw for Mr. Neuenfeld.
And are you Mr. Neuenfeld?
Yes, Your Honor.
And each of the cause numbers, I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kevin Neuenfeld who was placed on community supervision in 2023 CR 1478 for the offense of assault family second offense on July 20th, 2023 for a term of 10 years? Is that you?
Yes, ma'am. Here, Your Honor.
And are you the same Kevin Neuenfeld who was placed on community supervision in 2023 CR 5264 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on July 20th, 2023 for a term of 10 years?
Yes, Your Honor.
All right, state, are you proceeding on the same allegation in each motion?
Yes, we are, Your Honor.
Defense, any objection to the state reading the allegation once and your client pleading in both cause numbers?
No, you're,
All right, state.
Yes, Your Honor. Violated condition number 4 in Bear County, Texas, the defendant Kevin Newton, is it Neuenfeld? Neuenfeld. Did then and there fail to report to the supervision officer as directed for the months of October and November 2023 in violation condition number 4.
How do you plead to that in each of the motions, true or not true?
True, Your Honor. We'll waive the remaining violated conditions. Your Honor.
Any objections? All right. Did you understand by pleading true to violation of condition number 4 in 2023 CR 1478? Court could find it true, grant the motion, sentence you up to 8 years in prison and up to a $500 fine?
True, Your Honor.
Now, do you understand
Yes,
that?
ma'am. Sorry.
Knowing that, do you still wish to plead true to violation of condition number 4 in that cause number?
Yes, Your Honor.
Court will find violation of condition number 4 in that cause number true. Did you understand by pleading true to violation of condition number 4 in 2023 CR 5264? The court could find it true, grant the motion, sentence you up to 8 years in prison and up to a $500 fine.
Yes, Your Honor.
Knowing that, do you still wish to plead true in that cause number?
Yes, Your Honor.
Then and that cause number, the court will find violation of condition number 4 true as well. Is there a proposed agreement?
There is, Your Honor. And that is to deny the motion to revoke, continue him on his probation with weekly reporting for 60 days. Also intensive outpatient, also a UA hotline till further notice. And I believe it's 90 days of UA, I'm sorry.
Over days. Yes.
Vashon said it. And
90,
I believe he does have verification that he did the BIP.
All right. So he has verification of that?
yes, Your Honor, and I just emailed it to the state. I can provide the court a copy of that.
All right, probation,
Yes, Your Honor.
what is your recommendation? All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Kevin Neuenfeld.
All right, explain to me why you're not reporting.
Well, I had a baby born with a very young lady that abandoned the baby pretty much right after having the baby. I was trying to deal with the CPS case, the stress of that. Trying to get custody, doing it was, the CPS was, through Zoom and everything. I paid for a paternity test. I'm 99.9997, the father, trying to get custody of the
But it's,
baby.
you're not concerned about that 0.1%.
Not at all. The
Okay,
baby looks just like my other two daughters.
okay.
So I'm trying to deal with that and trying to. I'm trying to keep her around, but I just can't. She's too much trouble. She's a liability to all my freedom and all that. So the baby mom, not the daughter. The daughter, I love her.
Child's mom.
Thank you for saying that. I don't know why people say baby's mom.
Daughter's child.
Child's mother.
Child's mother. Sorry.
All right.
Yes, yeah.
And how old is she? The child's mother?
24,
And how old are you?
43.
All right. Well, that's on you for doing that.
Touche.
Oh, you're throwing French down to me. All right. Then what the court will do, and each motion, the court will deny the motion. Alternate amend conditions. There's to be CPS compliance. And each cause number. What is the name of the mother of your child?
Savannah Cuellar?
Savannah Cuellar.
Yes.
There's to be no contact with Savannah Cuellar. And the reason why I do that is because if you're saying she's not a good person to be in your life, then this is me helping you with your probation. So if she wants to have contact with you, you can say, the mean judge in the 187 said you can't have contact. There is to be 90 sober meetings in 90 days. Probation, do we need an updated TAP or no?
No, sir.
All right, there's to be intensive outpatient treatment. And the UA hotline. Probation with regards to the weekly reporting. I think he's going to have a lot on his plate with CPS. So I think adding, you need to unfold your arms. They say when you fold your arms, you're closed off to what people are trying to give you.
I want to be receptive.
All right. So probation with regards to weekly reporting, I think that may be too much. All right. So are you all fine with not doing weekly reporting?
Yes, Your Honor, thank you.
All right. And probation, are you fine with that? All right. If you miss reporting, what's going to end up happening is you're going to come back here. Motion's going to be issued. And you're looking at 8 years in prison. And guess what? If you go to prison for 8 years, one, because it's a newborn baby. I've done CPS cases. Everybody always wants a newborn because they figure a parent has not had a chance to impact them negatively. And they would be happy to take your newborn, and then you'll go to prison. Either you'll do a Cape Fear, tattoo your knuckles or not. And then when you get out, your child won't know you. You understand? Is there anything else you need from the court in order to be successful? All right, we can go off the record. Good luck to you. Hey, did you ever watch the series Shameless
No, I haven't.
with Carl?
No.
Okay, you need to watch that,
Okay, I will.
but don't pick up any bad habits from that series.
Okay, Your Honor.
All right, if you ever need anything and you feel like probation is not addressing it, you can always come back to court. Yes, Bashan?
I just need direction on whether or not you're gonna give them credit for the DIP.
Give you credit for any time served. There's an affirmative finding of family violence. Take in consideration 2024 CR 0694. And you're asking that the misdemeanor cases be taken in consideration as well?
No, but they do run concurrently.
Right. Then concurrent with County Court Cause number 723-843, 684-636. And there's to be no contact with Lamisha, Lameisha, Gunnels, Gunnels. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
34.
34.
Yes, ma'am.
All right, you're gonna have to make a decision. Either you're gonna continue going in and out of somebody's jail, in and out of prison, or either you're gonna get your life together. Time passes by so quickly. Once you each reach the age of 21, then years start flying by. And you wake up and you're institutionalized, and a majority of your life has been spent in prison. If you don't want that to happen to you, you're gonna have to make better decisions. You understand?
ma'am.
All right, good luck.
In Judge Boyd's courtroom, Michael Ruano finds out what happens when you ignore a protective order case and skip probation. After months of blowing off check-ins on a felony bond violation with family violence priors, the judge revokes his deferred deal and hits him with 5 years in prison, plus a ban on owning guns and no contact with the victim. Is this real accountability, or still too light for repeat protective order violations? Comment your take, and don't forget to like, share, and subscribe.